25-03267.
Anna Buckingham for the people.
Assistant Public Defender Lauren Sutter on behalf of Ms. Bellicon. I think there's been a motion to substitute counsel filed yesterday.
Haven't signed it.
Understood, which is why I'm still hearing right now.
You already put them on the docket. Haven't signed a substitution. You do that. Okay, you want to sub in?
Sorry, Your Honor.
Okay. This matter was scheduled for jury trial today, but it was not the priority case, so it needs to be reset anyways. And so we will move the public defender's office off of the file. You're going to take over, Mr. Cruz,
Yes, Your Honor.
and I'm assuming you have not yet gotten discovery.
I'm sorry.
Have you gotten discovery yet?
We have a police report. Any videos yet?
Yeah, this matter set for jury trial. April 21st. Do you think you need another final pretrial?
Couldn't hurt, Your Honor.
In there, would it be possible to withdraw the trial documents I previously filed so that he can handle whatever he feels appropriate for it?
Filed some documents, they're not in my file, so I don't know what they are.
It was just the trial documents exhibit.
Oh, okay, yeah, but my staff have yet to put it in the file anyway, so.
Very good.
Let's see. I'm going to set up for another final pre-trial. We have the victim here today.
Yes, Your Honor.
I'm not requiring the victim to come for the final pre-trial. March 3rd. March 3rd at 8 a.m. Then jury trial, April 21st. Jury trial, April 21st. That works for you, Mr. Cruz?
April 21st.
Correct.
I am scheduled to begin a homicide trial at Circuit Court on the 20th. And I think it's a date certain. Mr. Dwayne's the prosecutor on that.
April 28th.
That we will probably be done by then. Yes.
April 28th. 8 o'clock in the morning, in person at the court. Do you have any questions for the court today, ma'am?
No, Your Honor.
Any additional matters for the record?
No, Your Honor.
Just if I can get a signed copy of it so I can close our file internally of the substitution. Thank you.
Thank you. You still up? Oh, I didn't cross anything off.
But are we all set on that?
Yes, thank you.
I meant to take yours, but there's interpreters on. Print out the code.
What is practice? Oh, State of Michigan versus Brianna Cannon. 4-01060, appearance, please.
Anna Buckingham for the people. Assistant Public Defender Justice Strong on behalf of Ms. Brianna Cannon.
Cannon is scheduled today for a final pretrial. This is a trial in this court. We're moving to dismiss
Correct, Your Honor.
in the interest of justice.
Correct.
Give you a copy of the dismissal in just a moment. They do have the right to reissue the charge against you. Do you understand that? Any questions? Okay, you're all set. Thank you.
Thank you.
State of Michigan versus Matthew Christie, 25-02579. Appearance, please.
Anna Buckingham for the people.
Assistant Public Defender Lauren Sutter on behalf of Mr. Christie. Your Honor, I have attempted to call Bear River to speak with him. Because of HIPAA, they will neither confirm nor deny if he's there, so I've been unable to make contact with him. I haven't seen him today in person or on Zoom. It is my understanding that Mr. Zaney was here.
Sure, big short. State of Michigan versus Kendra Freeman, 25-02185. Appearance, please.
Anna Buckingham for the people.
I apologize, Your Honor, I spoke over you. What was the name you called?
Kendra Freeman here.
I did not mean to, Your Honor.
You did not have contact.
She said, no, I did. I spoke to Ms. Freeman last week, that she'd be here. I'm not sure if she's running late.
Your Honor, the people are going to nolly this case. We haven't been able to make contact with the victims in any manner.
Okay, yep. Now you prepared. Let's see. State of Michigan versus Tyrone Plummer, 25-01667.
Anna Buckingham for the people. Assistant Public Defender Justice Stroud on behalf of Mr. Tyrone Plummer, please stand to my right.
Scheduled today for a jury trial. Here that there was an offer. Time served, which he's already got credit for that for the bond violation. Now you want to give him credit for the underlying charge. He's likely to be on probation, just so we're clear. How do you want to proceed?
To try to,
April 21st at 8 a.m. We have the witness here today.
Your Honor, in anticipation for the plea, he did not come because he is homeless and had difficulty getting here, but we are communicating and he will be here for the trial and has appeared at the previous hearings.
We're gonna subpoena some people that.
Any additional matters for the record?
not the people. Nothing further, Your Honor. Thank you.
Thank you. The State of Michigan versus Amy Stamper, 25-02041. Please.
Anna Buckingham for the people.
Stamper.
Support David B. Carter Jr. on behalf of Ms. Stanford.
Stamper was scheduled today for jury trial. In that we're running a priority case today. So this one can't run. She was continuing to come. Is that
Yeah.
correct?
Yes, Your Honor.
So we'll have to reset it.
April 28th.
April,
I'll be in trial.
May 5th at 8 a.m.
May 5th, 8 a.m. Any additional matters for the record?
Not from the people.
Not for the
Get your notice to appear. State of Michigan versus Adrian Mendoza Cruz, 25-03470.
Anna Buckingham for the people. Assistant Public Defender Justice Rob on behalf of Mr. Adrian Mendoza Cruz. We also have an interpreter with us this morning.
State your name for the record.
Norma Batista.
You solemnly swear or affirm that you are interpreting the matter before the court completely and accurately and not divulge confidential communication to help you God.
I do.
Today was the date scheduled for a jury trial with this? No, this was the final pre-trial. I require interpretation to be done on the record in case there's later an appeal.
Yes, Your Honor.
Can you pick up what
Can
you're
you hear
saying?
me?
No.
Yeah, it has to be loud enough, so if he ever appeals and says they weren't saying what they were supposed to be saying, we know what was said.
Es importante de que usted sepa de que si quiere apelar, esté informado de que lo puede hacer.
Okay, and so I have a plea offer here.
Entonces hay una oferta que se le está haciendo,
It says that you're gonna plead guilty to count 2.
que usted se consiga culpable acerca del cargo número 2,
Malicious destruction of personal property.
que significa que es maliciosa destrucción de propiedad.
I'm sorry, that's count 1.
Ese es el caso número 1, no el número 2, se está corrigiendo.
Count 2 of assault and battery will be dismissed.
El caso acerca de asalto no va a ser considerado.
And with a sentencing agreement of no probation or jail.
Y la sentencia va a ser de no hay probación ni tampoco tiempo en la cárcel.
Is that accurate?
Yes, That's Your Honor.
El abogado del Estado aceptó la oferta
Is there restitution?
There is no restitution.
y no hay restitución.
And has your client been advised that a Killable agreement has nothing to do with me?
Y sabe que todo lo que se le ha ofrecido no tiene absolutamente nada que ver con el juez.
And I'm the one who decides the sentencing.
Y ella es la que decide la sentencia.
So you need to be advised that that's an agreement between you and the prosecutor.
Y entonces se está recordando de que eso fue un acuerdo en que llegaron los dos abogados.
I am not a party to that agreement.
Ella no está parte de el acuerdo que los abogados hicieron.
I don't have a clue what's on his criminal history at this time.
En este momento, ella no sabe si hay algún otro crimen en contra suya,
But he's likely to be put on probation.
pero puede que se le ponga todavía en probación.
Your Honor, for consideration of this court,
You haven't advised him yet.
you could potentially have to face a sentence under the judge's discretion that does not include what we agreed to.
Hay la posibilidad de que el juez le dé una sentencia que no tenga nada que ver con lo que los abogados acordaron.
She can decide to still have you undergo probation.
Ella todavía puede dar información si ella quiere.
With that understanding, he still wants to move forward with the plea.
Con eso que le dijeron, todavía usted quiere considerarse culpable. Yes.
You want me to consider something?
Yes, Your Honor. So in this case, there are immigration concerns. As we understand it, there is currently an ICE hold. Sorry.
En este momento, ella le está diciendo, estoy recordando de que esta persona puede ser recogida por inmigración.
As we understand, there is an ICE hold for Mr. Mendoza Cruz. And so our objective with this arrangement is to avoid potential deportation activity.
Ella le está recordando a la persona que se lo puede recoger en inmigración. Y entonces, por eso ella le está presentando esta oferta al juez.
We are concerned that with the oversight of probation or with him being in custody, that it will likely lead to him being taken from
ella dice que si le da aprobación y también se le, o se le da una sentencia de claro que se le lleven a la cárcel, esto puede dar una pista de inmigración.
The criminal conviction is what flags it. Not the probation, not the sentence.
Entonces ella dice, eso no tiene nada que ver con aprobación, sino con la sentencia.
So if that's a concern, him taking the plea, that's why I advise this could have an impact on immigration status. The ICE gets flagged at the conviction, not because of how you were sentenced.
Entonces la jueza le está recordando a su abogado que inmigración lo puede recoger después de la sentencia.
In light of this development, you are allowed to revoke your plea.
Y entonces su abogado está diciendo que en vista de lo que está diciendo la jueza, usted todavía quiere con conseguirse culpable. Que hay la posibilidad de una parte o la otra.
Would he like additional time to consider before he moves forward?
Entonces está dando tiempo para que usted considere lo que se está diciendo. Ellos no tienen nada que ver con eso. No tienen nada que ver con eso. Entonces,
No, we know ICE agents. Just saying.
Your Honor,
I'm sorry.
Your Honor, he was given the information.
He wants more time.
Yeah, and he said, yes, I'm informed.
Is this a mutual concern of the prosecution?
The prosecution, in light of that concern, has revoked the assaultive crime. That's the extent, the offer that we've given is the extent we're willing to go with
Okay.
this. We do have the victims present and ready to cooperate if we need to proceed.
Está diciendo, le pregunto a los abogados si ellas dos habían estado de acuerdo con lo que su abogado está presentando y ella dijo que sí.
We already have a jury trial date.
Entonces, le dice, ok, déjame ver qué es lo que necesita.
That gives him additional time to consider that there are potential real ramifications of him entering a guilty plea.
Entonces, ella lo que está es pidiendo que se le dé un poco de más tiempo para que usted entienda completamente cuál es el proceso que se le está haciendo.
And so he just needs to notify us the Friday before
Entonces, tiene que notificar el viernes antes
if he is going to enter a guilty plea to the count one.
si todavía usted va a aceptar de que es culpable del cargo que se le está.
So that the victims can be properly notified that they don't have to appear.
Y eso es para darle tiempo a las víctimas o a las mujeres que se les está acusando también de ver cuál es el proceso y qué es lo que está pasando.
Okay? Have any questions for the court?
¿Tiene alguna pregunta? No.
Any additional matters for the record?
Not from the people, nothing from your honor.
Okay, you're all set. State of Michigan versus the Clarion Brandon, 25-0361112. Did you see him yesterday? The Clarion, the name sounds familiar. Is the Clarion Brandon here?
Caught him in.
I think he's already got a warrant anyway, so. The State of Michigan versus Delia Moore, 25-01543. Appearance for the record.
Here for the people. Oh, I'm sorry, Assistant Public Defender Justice Drive on behalf of Ms. Delia Moore, who is standing to my right.
Okay, and Ms. Moore has a dog at large. Was this resolved or?
I have
the
not,
Possibility of resolution?
there's a possibility of resolution. I have not discussed yet with council. Do you have anything?
Not at this time, Your Honor. So we
On
would
the
ask-
second pretrial?
Yes, please.
February 24th at 10:30.
February 24th at what time? At 10:30. You have any questions for the court today, Ms. Moore? You get your notice to appear, and then if your attorney will talk to you about your options for a resolution for this matter, okay? Let's see, State of Michigan versus Jason Sala, 25-00533.
Anna Buckingham for the people.
Assistant Public Defender Justice Drive on behalf of Mr. Jason Sauer, who I don't believe is here, Your Honor.
Yeah, my last note said he was in TRICAP.
And
This
I-
was set for a review. To see how long he will be in treatment.
I have tried to reach out to him, Your Honor, and I've not been able to get him on the phone.
Well, that's not the only option. He's in TRICAP on 25-00291. Did you contact the court to find out how long he'll be in treatment?
I did not, Your Honor.
That should be your next option. Or whoever his attorney is on that file, might be from your office as well. I'll reset the review so that you can do that.
Thank you. February 24th at 10:30.
February 24th at 10:30. State of Michigan versus Devon versus McKinley, 24-03208. Appearance.
Anna Buckingham for the people.
Lauren said she has to call.
Okay, so Ms. Sutter was on this matter?
Correct, Your Honor. And then after sending a restitution bill to Miss Sutter, she realized she's conflicted out. of
Okay,
representation.
so they need conflict, time to appoint conflict counsel.
That's correct, Your Honor.
March 3rd at
March 3rd at 10 a.m. will be your new court date, okay, sir? You have to get an attorney that doesn't work for the public defender's office, because there's a conflict, okay? You understand what's going on? I can't hear you on the record. Okay, you have any questions? Any additional matters for the record?
Not from the people.
Nothing further, Your Honor.
We'll get you a notice to appear for your next court date. Did you have victims that needed to be released? Did you have victims that needed to be released?
Yes.
Thank you.
My job.
Is it okay if I just do a lap real quick?
That's fine. I'm about to do a sentencing, which doesn't require the prosecutor. State of Michigan versus Andre Bashore, 25-03327. Here's for the record.
And please, the court, David B. Carter Jr. on behalf of Mr. or who is present standing at council table.
How are you today, Mr. Bayshore?
Fantastic.
That's wonderful. Okay, today's the date that was scheduled for sentencing. I do have a pre-sentence report. And it was prepared on the 4th of February. Council, you did get a copy of that, correct?
I did.
That's why I'm not familiar. I didn't take the plea. I think the visiting judge took the.
That is correct, Judge Paul did. I think it was Judge Paul.
It was Judge Paul. I can tell by the hearing. Okay, let's see. So, no need to make corrections, updates, or deletions. You can make allocation.
No additions, corrections, or deletions. As far as allocution goes, Your Honor, I'm asking the court to send my client to fines and costs. We were here when we took the plea. There was no really any objection to go to immediate sentence. It was pled to a disorderly person jostling. However, the victim had already left, so she couldn't come before the court. So the court felt compelled to send this over to pretrial services to do an updated, to do a PSI and to allow the victim to appear if she chose to do that. This is a very isolated incident, and I think it's a family matter in which maybe some hotheads got the best of at least my client. My client understands what happened here. He's embarrassed about it. He wishes to just mend the fences and move on. And we'd ask the court to consider fines and costs only under these circumstances.
Does your client want to make a statement?
Your Honor, I am apologizing on my behalf that this even happened. It's family and it should never have been brought to this level. It was just ignorance and immaturity on my part.
Okay, the victim is your mother-in-law? I'm just trying to gather, because I was not going to what took place here. And the victim's not present today, correct?
Correct.
Oh. So obviously, I did not wish to make a statement relative to sentencing. Who did you bring with you today? Who did you bring with you today?
That'll be my mom.
Oh, that's nice. Your mom came to support you in court today. I don't see where you've been in trouble before.
I have not.
Sorry.
I'm sorry. Being a commercial driver for FedEx Ground, I do my best to uphold the law and make sure I follow DOT regulations to ensure the safety of deliveries for my customers so they can enjoy their orders from online vendors.
It's unfortunate because this is a family dynamic, but it did say that you were forthcoming and remorseful, at least at the time of your meeting with our probation department. You appear to be remorseful. Now, what do you think though that you can do in the future to avoid something escalating like this? Because obviously you're not going to avoid your mother-in-law.
Well, honestly, Your Honor, I would prefer just not interacting with her because my wife and her also do not see really eye to eye. And my mother-in-law has said that, well, why did my wife marry me if I did such a horrible thing?
So you never got along with your mother-in-law.
Not really. Your
Right, so what I'm trying to understand is what a self-regulating things can you do? Or do you intend to do? So that even if you can't avoid her being at your house or you being around her, how do you protect yourself from being back in court?
Gotcha. Honestly, I'm just gonna not let anything get to me, Your Honor, because I never should have let my temperament get the better of me in the whole entire matter. I was just trying to help that day with their phones and just made me go to town, and I should just said, you know what? Gonna go any further, it's on me. I should have just left it be. So that's exactly what I'm gonna do, just not allow myself to put myself in a scenario like that, and my ability just to move past this and definitely move past it, Your Honor. And
If I may, Your Honor,
Yes.
that's an excellent question, and those are questions I asked my client at the beginning of this case. Well, what's going to happen in the future? And perhaps he's not as elegant, but we
That's why he
had.
hired you, or that's why he has you.
But we had discussed this, and it's basically he's learning to recognize when things are getting to a stress point, not engage. It's just for everything that he feels like he's helping or something, it's one of those situations where there's this inner tension between the parties, and he's just learned to just not engage, to leave the room politely, not engage, not say a word, not even do the or anything,
Right.
just not engage.
Yeah, because Mr. Carter, I mean, how long has your bride been married? How long have you been married?
coming up on 3,
So not long.
yeah, 3 years. in
Here's the
December.
thing, I can imagine based off very little about what I know about your family situation, including this, it's not gonna get better. You know, because now there's at least an interaction that you had that had to go through the court system. So I don't know that your relationship with your mother-in-law gets better through this. I shouldn't say it's not gonna get better, but this doesn't make it better. And so for you to say that I'm just not gonna let things get to me, we can say that until we're blue in the face. Things will get to you. You are a human. And so things are going to get to you. They're going to upset you. But it's about how you react when you are upset. Okay? You don't have to react every time you're upset. And sometimes when you get to that boiling point, you may need to take yourself out of the environment, even if it's your home. But it's for your overall sanctity and safety, and so that you don't end up with a conviction that caused you to lose your very good job and your well-being. So it's an unfortunate situation. Again, it was pled down to a Jocelyn. You have no prior criminal history. I'll deviate from the recommendation, which was for probation. I'll do a sentence of fines and costs. There is a $75 crime victim rights fee that must be assessed per statute, plus a $50 state minimum cost that must be assessed per statute. I'll also assess a fine of $300, so it's $425. When can you make payment on that? Are you
Can you
asking
do it
your,
in 30
are you asking your mom when you can make payment on that?
No, because I'm just trying to think, because I have my savings set up through her, because right now we
I don't need to know all your business
Okay,
about your finances. Just,
Yes,
and you don't
I
have to
can
pay the whole
do-
thing at one time.
okay.
When can you make a payment?
I can do it in 30 days.
Within 30 days, how much are you gonna pay?
I can do about 75% of that. Sorry, my bad.
And then you'll pay the balance within, what, 30 days from there? So how about I say you'll pay in full within 60 days?
That works, sorry.
what happens if you don't make the payments is if you can't make the payment, something goes on, right? You have an emergency, whatever. It's your responsibility to contact the court to ask for an extension. If you don't, they set it for a show cause. The clerk's office sends me the file. I don't remember when I see the file that you have to set it, you have a situation that you have to go through your mom. I don't remember all of that. All I see is that you're supposed to make the payment within 60 days. So if you find that 60 days is coming and you've not made the payment, you gotta call the court or come down here and ask for an extension, okay?
Absolutely.
Do you have any questions about how you make the payment?
Yes, actually,
So there, the window you're gonna pass on the way out here to your right, that's the criminal traffic window. You can come in person and make the payment there. You can make the payment online. You would use your case number 25-03327 to make payment online, or you can mail a check or money order to the court, also putting that case number on, okay?
gotcha.
Do you
Okay.
have any questions about that?
No, I do not.
Any additional matters for the record?
No, thank you, Your Honor.
Thank you. You're awesome. Let's see. It's early for 10 o'clock. We have. Oh, sure. I don't see the, see the jury stuff or the things they filed.
I mean, both of them.
I did forward it to you. They have to be put in the file in the future. They're filings.
He's the writer.
Who's on the iPhone? Where did you see him this way?
Yeah.
Is that Bridges? Who's representing Bridges?
I am.
Ms. Schwab,
Are we ready on Mr. Bridges? State of Michigan versus Jesse Bridges. I have 25-01221 and 1222 appearances.
Anna Buckingham for the people. Assistant Public Defender on behalf, Jessica Stroud on behalf of Mr. Jesse Bridges, who is here remotely.
Your Honor, the people will be dismissed in this case.
I'm sorry, I was just laughing because I looked at, I'm assuming this is Judge Bond. $1,000 cash bond. My dog at large is that I had to smile. Awesome. All right, these cases are dismissed. You're all set.
thank you, ma'am. You have a good morning. See you April
Thank
6th.
you. Oh, boy. See you soon, sir. You won't be driving.
Oh, no, I'll talk to you later.
State of Michigan versus Beatrice Navarro, 26-0181. Council appearances.
Anna Buckingham on behalf of the people.
Good morning, Your Honor. Attorney Lawrence Sutter on behalf of Ms. Navarro, who is standing to my right.
This is a pre-trial for an assault and battery. Was there an offer extended yet?
Not at this time.
We'd be requesting final pre-trial, Your Honor.
Final trial, March 3rd at 8 AM. Then jury trial, April 21st at 8 AM.
Okay, March 3rd in person at the court will be a final pre-trial, and then you're gonna have a jury trial currently scheduled for April 21st. I say currently scheduled because there's multiple scheduled for that date, and you do not have the priority case number, okay? I mean, you don't have the oldest case number. So your case may not be able to go on the 21st if an older case needs to go, okay?
Okay.
But you do need to appear on both days. March 3rd, you'll appear in person. And we'll see if the victim appears, okay?
On March 3rd.
On March 3rd, okay?
Okay, at
Yeah,
what time? You're on
8 a.m.
8 a.m.
We're
Okay.
gonna get you a notice in just a moment. Do you have any questions?
I just have a question. Why am I the,
Nope, we're gonna.
oh, I can't.
That's what-
I don't know anything about
Oh,
this case. I
gotcha.
couldn't tell you.
It's kind of,
Yep,
Yep.
we're discussing it.
oh,
Oh, any additional matters for the record?
Oh, Your Honor.
Nothing further, thank you.
Thank you, you're awesome.
Just make sure- Yeah, yes, ma'am. Thank you very much.
Who's that lady? Is she waiting for court? Yeah. Oh, that was doing a little something different, huh?
Yeah, she got something going on.
Got it. I'm not.
I'll come.
Thank you.
I can't hear nothing.
No, I'm in seven.
Is Brenda McDonald here?
She's
Okay, State of Michigan versus Sunday McDonald, 26-00101, appearance, please.
Hannah Buckingham on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Ms. Brenda McDonald, who is here remotely.
Okay, this was a pre-trial for animal abandoning cruelty. Was there an offer to resolve this?
The offer is abuse, neglect to one animal rather than to agree and an agreement not to own dogs.
How does your client want to proceed?
Your Honor, she would like a little bit of time to consider that offer. It was just made yesterday. I just made her aware of that offer today. So
The
it's-
first, second, pre-trial.
February 24th at 10:30.
February 24th at 10:30, okay, ma'am? Your sound is out. You're muted.
Okay, I'm sorry, I'm not good with this. Yes, it was muted. I understand, yeah.
No problem. Do you have any questions for the court?
No, not at the moment.
Okay, any additional matters for today's record?
Not from the people.
Nothing further, Your Honor. Thank you.
Thank you, you're all set. State of Michigan versus Barnett, Racovan, 26-00099, appearance, please.
Hannah Buckingham on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. Rackman, who is here to give so.
Okay, today is the date for Mr. Racovan to have a pretrial. This is for malicious destruction of a building. How are we proceeding?
Your Honor, we plan on doing a plea. I'm currently filling out that form.
The offer.
The offer is amending count 1 to malicious destruction of building under 200, under 750.3805, plus an agreement to pay restitution, plus an agreement to 30 hours community service, no upfront jail.
Doesn't he already do community service? List his job as volunteering. Where's he volunteering?
Where do you volunteer?
Oh, I do volunteer work with various mutual aid networks, Rent is Too Damn High, Punks with Lunch, things like that. I'm also in group chats where anytime anyone needs help with anything, like if they get evicted and they have to like leave on short notice, I immediately sign up to help them relocate their belongings elsewhere. I've done
He doesn't have
cleanups
a
at
full-time
homeless
job.
encampments. It's what?
You're not employed.
Not at the moment, but I'm not idle either. I do volunteer constantly.
You say you're on what?
I am unemployed, but I'm not idle either. I volunteer
Not
constantly.
asking you about how you're idle. I'm asking you how you pay your bills, because there's restitution, so I'm trying to figure out how it's gonna get paid.
Um, um, I do make money selling art I make frequently.
Oh. What's the restitution amount?
Restitution is $756.32.
I also have friends that are willing to help me cover that.
Okay, so you would like to accept the offer, which is to plead guilty to an amended count of malicious destruction of a building less than 200. You will pay restitution, $756.32. What was the other portions of the agreement?
An agreement to 30 hours community service.
And to do 30 hours community service. I will tell you where you'll do your community service if I accept that agreement. You understand that?
Okay.
If you want to move forward with that offer, you can raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Okay, you have the following, you can put your hands down. You have the following rights that you would need to understand and then be willing to give up if you wanted to move forward with the plea offer. First is your right to the presumption of innocence. You're innocent until proven guilty. You have the right to proceed to a jury trial and require the prosecution prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any witness called to testify against you. The right to call your own witnesses to testify on your behalf. The right to present evidence that you believe show a defense of the charges, and the right to remain silent, not have it used against you, or waive silence and testify at your own trial. You understand that?
I understand.
You're willing to give up rights?
I am.
Anyone promising you anything to get you to want to give these rights up?
Does the plea deal count?
Okay, any threats being made to you to get you to waive your rights and plead guilty?
No.
Anyone coercing you to enter a guilty plea?
No.
You understand that by entering a guilty plea, it could result in a conviction that you may need to report to your current employer or to a future employer.
I do.
It also could have impact on travel or immigration status. You understand that?
I do.
Okay, as to the malicious destruction of a building less than 200, how do you plead?
I plead guilty.
Got a factual basis.
Barnett Racklevan, were you on or about December 31st? Actually, okay, Barnett Racklevan, were you on or about January 6th of 2025?
Here, 124 West Michigan now.
I'm so hard of hearing you.
124 West Michigan Ave, which is the building we're in.
Yes, 124 West Michigan Avenue in Lansing, Michigan, in the county of Ingham.
Did you say 2025?
I said 2026, excuse me.
Oh, I'm sorry. Okay. Yes.
Okay. And at that location, Did you injure a building?
Injure?
Yes.
Did you
Yes.
cause destruction to a building?
Yes.
By spray painting it?
Yes.
And was that destruction valued at less than $200?
Yes.
And did you do that intentionally?
Yes.
Do you think that satisfies the factual basis?
People are satisfied with the factual basis.
What did you do to the building, sir?
Spray painted homeless people or people on the front doors.
Thank you. Okay, and the value, although you're pleading to a factual basis less than 200, the value actually was $756.32, correct?
Yes.
Okay. Any additional questions?
Oh, you're right.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made. I'm just waiting for its criminal history to be printed. Off the record on that for just a moment, sir. Take the next case. Is Xavier Rye here
This might be a dismissal, Your Honor.
on both cases?
I only see the insurance cases.
There's a traffic signal violation and a security failure. Oh, it looks like you might have already defaulted on the traffic signal, that's why. Did they set it aside? Let's see. 20th. They must have. What are we doing?
I've been provided with proof of the insurance portion of that.
The traffic signal violation. Is he accepting responsibility to that? Fine is $135. What are you paying that? You gonna pay it today? We'll get you to the window so you can make payment on that. And the security failure is dismissed. You can have a seat until the court officer can take you to the window, okay, sir? No problem. Let's see, State of Michigan versus Rachel Service, 24-02725 and 26-00255, appearance please.
Anna Buckingham for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of the service who is joining us via Zoom. If I may approach with paperwork.
Okay, the service is going to plead guilty as charged.
In one of the files, Your Honor.
I was
The
gonna say
other-
this only addresses one. file.
That's correct. The other file we'd like to set for final trial.
Okay, so she's gonna plead guilty to retail fraud. There's restitution owed to Meyer, $63.45.
Yes,
Okay, and a kilogram time served.
yes.
You want to accept that offer, ma'am? I couldn't hear you. I couldn't hear you.
Yes,
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
yes,
You can put your hand down. You have the right to take this matter to jury trial and maintain your innocence. You're innocent until proven guilty. Do you understand that?
Your audio is not so good. Can you speak up just a little bit?
yes,
Okay, you have the right at the time of trial to maintain innocence. The prosecution would again need to prove each element beyond a reasonable doubt. The prosecution has the right to call witnesses which you can cross-examine or question in court at the time of your trial. You have the right to call or subpoena witnesses that will testify on your behalf at your trial, and the right to remain silent and not have it be used against you. You understand each of those rights, ma'am?
yes,
And you're willing to give those rights up?
yes,
Anyone promising you anything to get you to waive your rights and plead guilty?
no,
Any threats or inducements to get you to enter a guilty plea? Say it again. I don't know why it's not picking up your voice.
Oh,
Okay. Are you on probation or on parole? You stand up, please.
no, I'm
Say it
not.
again, say it again. Okay.
No,
You understand? Thank you. You understand that by entering a guilty plea, it could result in a conviction that you may need to report to your employer?
yes,
That also could have an impact on where you can travel or get immigration status. You understand that?
yes,
As to retail fraud in the third degree, how do you plead?
guilty.
Factual basis.
Thank you. Is it true that on or about June 12th of 2024, you were present at or near 6200 South Pennsylvania Ave, commonly known as Meyer?
Yes,
Is that in the city of Lansing, Ingham County, Michigan?
yes,
And is it true that at that time that business was open to the public? And did you take items from that store without paying for them?
yes,
Items that normally are offered for sale?
yes,
And the value of those items was less than $200, correct?
yes.
Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from the prosecution?
No, Your Honor, we're satisfied.
I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. A restitution will be ordered payable to Meyer at 6200 South Pennsylvania in the amount of $63.45. Looks like she's had a bond 510%. At least for a week or so, let's see.
I have it at 15 days from the 27th of January.
Credit time served. And we're all set on that file. And then the other file, which is the breaking and entering, you wanted final pretrial?
Yes, Your Honor.
March 3rd at 8 a.m.
March 3rd at 8 a.m. in person at the court. Well, she's gonna be in custody then?
Your Honor, she's an expected out date of the 24th and 55th. She may be written to Eaton after that. I don't know if she'd be released immediately after, so it's possible she'd be released by the 9th.
I'm sorry, she has a,
Here in Ingham County, she is sentencing in front of 55th District Court on the 19th and expected out date of the 24th is what she advised.
19th of this month?
Of February. And then she expects to be written over to Eaton. I don't know whether they'll release her immediately, so it's possible that she will be out of custody on March 9th. It's possible she'd be in Eaton County at that time.
She's gotta pay the bond here, which is 510%.
Yes, she is aware, Your Honor.
Okay, all right, so we'll note that she's in custody, at least until April, sounds like. March 3rd in person for final pretrial. When's the jury trial?
April 21st at 8 a.m.
April 23rd?
First.
April 21st at 8 a.m.
Thank you, Your Honor.
Do you have any questions today, Ms. Service?
No,
Additional matters for the record.
Not from the people. Nothing further.
You're all set, ma'am.
thank you.
You're welcome. Back on the record in the matter of the state of Michigan versus Barnett Rackavan.
Anna Buckingham for the people. Assistant Public Defender Justice Strong on behalf of Barnett Rackavan.
Mr. Rackavan.
Sorry, I'm here. I had everything muted because my neighbors decided they're gonna start doing carpentry out of nowhere.
You have the right to do carpentry in the middle of the day, I guess. You can make allocution.
Mr. Rackavan fully accepts responsibility for his actions in defaming this building. He is very forthcoming with his willingness to work off what he has done and to completely pay the restitution. In light of these facts, Your Honor, we would ask this court to honor the Kilbrew.
Does your client wish to make a statement?
Mr. Rackavan, would you like to make a statement?
I don't know what I would even say.
I reviewed his criminal history. There's no other convictions. So I'll adopt the Killebrew agreement. He will be ordered to pay $756.32. When are you paying that, sir?
I can start today with, but I will have to have a payment plan.
What are you paying today?
I have 20 in my pocket right now, and then I have friends I can ask, and I'll have to do a bunch of dishes and house cleaning if it's higher than that.
Okay, you're gonna pay $20 this week, and then how much do you intend to pay until paid in full?
What is the minimum? Is it 20 a week?
No, you don't need to pay 20 a week. That's why I'm asking you. You can pay 20 a month if that's all you can do.
I think I can manage 20 a week.
I'll note that you'll pay $20 by Friday, and you'll pay $20 weekly until paid in full
Okay.
by the Friday of each month.
Where do I bring the money?
You'll come down to 124 West Michigan Avenue. You'll go to the 6th floor, which
Sixth
is the
floor?
court. The 6th floor, yes. And then when you get off the elevators, you'll go down to the criminal traffic window to make your payment there, okay?
Okay.
Okay, 30 hours of community service is ordered. You'll complete all 30 hours at the LMTS Outreach Center. Okay?
LNTS?
L as in life. M like Mary, T like Tom, S like service, okay? LMTS Outreach Center is where you will complete your community service. Do you have any
Okay.
questions about that?
LMTS. The address, I suppose?
Looks like it's 1122 West Holmes Road.
122 West Holmes Road.
I don't think that's it.
They got a couple. All right, a couple.
We'll give it 1122 West Holmes, suite number 3 is what it says. So we'll go with that.
1122 Suite 3 on West Holmes.
On West Holmes, that's correct. And you will let them know that Judge Simmons sent you
Judge Simmons.
to do community service. You will need to report and turn your community service hours in to our probation department
Is
within
that
30 days.
is that going to be in the same on the 6th floor as well?
They're on the 5th floor. I'm gonna give them 60 days, actually. I'll give you 60 days to complete your community service.
Just in case I missed anything, could I get all of this information in an email?
Your attorney can email you.
Okay.
Any additional questions, sir?
I can't think of anything else at this moment.
If you think of something later, just reach out to your attorney, okay?
Okay.
All right, any additional matters for the record?
Your Honor.
Nothing further, Your Honor. Thank you.
Thank you, you're all set.
Does that mean I can leave Zoom?
Yep, you are free to go, sir.
Thank you, and have a good day.
Same to you. Let's see, State of Michigan versus Tracy Young, 26-00267. Appearance, please.
Anna Buckingham on behalf of the people.
May it please court, Dan Doe on behalf of Mr. Young, who's present and standing to my right.
Mr. Young has an assault and battery free trial today. Are we extending an offer at this time?
Not at this time, Your Honor.
Want a final free trial?
That is correct, Your Honor. We are requesting a final trial.
March 3rd at 8 a.m.
March 3rd, 8 a.m. in person at the court. Jury trial and pre-trial.
Pre-trial April 21st at 8 a.m.
April 21st at 8 a.m. for jury trial, okay? Also in person at the court. You have any questions today? We're gonna get you your notice to appear. Any additional matters for the record, counsel?
Not from people.
No, Your Honor, thank you.
Thank you. State of Michigan versus Prentice Smith, 26-00174. Appearance, please.
Anna Buckingham for the people.
Good morning, still, I think, Your Honor, Assistant Public Defender Lauren Sutter on behalf of Mr. Smith. Your Honor, I haven't seen him today. I was not aware he was on.
He's present, he's
Your Honor, I haven't had the opportunity to speak with him. However, we will be setting for a final pre-trial today and I can talk to him afterwards.
Mr. Smith, did you try to contact him?
I spoke with his mother yesterday. She said she was gonna give him a message to be here.
Mr. Smith, did you not to be here or to call you so you can talk about things?
Both.
Okay. Did you get a message that you were supposed to talk to your attorney?
No, ma'am.
Oh. Okay, final pre-trial, no offer?
Correct.
March 3rd at 8 a.m. for final pre-trial.
March 3rd, 8 a.m., you need to appear in person, okay?
Okay.
April 21st for pre-trial.
April 21st, 8 a.m., also in person. You don't have your own phone?
Not at the moment.
Okay, so how do you expect your attorney to get in contact with you?
My mother.
No, that's not gonna work, because she spoke to your mother yesterday and you just told me you didn't get the message. How is your attorney supposed to get in touch with you?
I'll be able to call her.
You said what?
I'll be able to call her off my mother's phone.
Oh, okay.
I did leave my phone number with his mother yesterday.
Yeah, but what I'm telling him is it's not appropriate because you left a message to his mom yesterday, he didn't know anything about it. So that's not gonna be a viable mechanism. How old are you, sir?
20 years old.
And you're facing 93 days in jail. So you probably wanna take matters into your own adult hands and make sure you are talking to your attorney before you go to court. You understand that?
Yes, ma'am.
Any additional matters for the record?
Anything further, Your Honor, just if it's possible, can I get into a breakout room with him?
Are you done with your cases today?
I believe so, Your Honor. I think the only thing I've left is the afternoon, which I could have a question on for you, but that's all of mine for the morning.
Okay. Was that what you got, something about Gino Garcia?
Oh, he's from the city yesterday. I saw his arms. Probably at my paralegal.
Is that your place?
Yes.
Mr. Garcia?
Yes.
Mr. Garcia, why weren't you here yesterday?
I had the dates wrong, I guess. I'm looking at the paper now.
Okay, your matter has to be reset because this is not a city day.
Okay.
March 2nd at 1:30.
March 2nd. 1:30. That's the second, not the third, okay?
Okay.
Send a notice to the address on file. You're all set.
Thank you.
Thank you. State of Michigan versus Kelly is it DAS? 26-00113.
Anna Buckingham for the people.
Assistant Public Defender Justice Strong, I have Ms. Velasquez standing to my right.
Okay, Ms. Velasquez has a retail fraud. Is there an offer at this time?
Your Honor, there's currently a pending case ongoing in 55th. We're hoping to do a global resolution with that case, so we would just ask for a final pre-trial to be set.
There's gonna be a global resolution in that case. And what's the goal here?
The goal is dismissal of this case. At 55th.
Set it for the second pre-trial, please.
Do February 24th at 8:30.
February 24th at 8:30. You have any questions for the court, ma'am?
No.
Submitted by mass for the record.
From the people.
Nothing further, Your Honor.
Mr. President, any? Maybe. Okay, on the record in the matter of the people of the state of Michigan versus James Nash, 26-00242. Have we seen James Nash? Someone is on Zoom. But they have not started their video. Oh, I just did it. Can I send me a Facebook post real quick? No. Sir,
Yes, I'm here.
okay. You're James Nash?
Yes, ma'am.
Okay. Do you have an attorney?
You said, do I have an attorney?
That's what I said.
Yeah, they said they appointed one to me, but I ain't speak to nobody here. I got an email.
Who said that?
I got an email yesterday. I think her name is Mandy Gilpatrick or whatever.
You got something that said he was denied? We got notification that he was denied.
Oh. He is assigned to me in our system, Your Honor. I have an appearance.
We don't have an appearance and we got a denial.
Got it on 30th,
January 30th for denial was sent. So an appearance was filed by you, your office when?
Looks like just yesterday, Your Honor. So he was originally denied. It looks like they, there was a resubmission for us to re-review him, and that was approved.
Someone's gonna need to get an appearance here, because we've not received it, and then it sounds like you've not met with him.
That's correct, Your Honor.
He's gonna appear in person for his next court date. Set it for another pre-trial. So that they can get this, I'm assuming, did you get discovery?
March 3rd at 10.
March 3rd at 10, you must appear in person, okay, sir?
March what? I can hear you. Sorry.
March 3rd at 10.
All right.
Okay, did you want him to hang tight so you can meet with him now?
No, Your Honor, I'll call him.
Okay, you're all set, sir.
Thank you.
You're here.
Yeah, Susan.
I was gonna say, Bob sent your email too.
Is that what?
When are we gonna come get the juror?
I'm like, can we?
Is it a joke? What do they think we're doing in here? We're doing a docket.
Exactly.
Oh, hey, look,
It's 11. Aiden Mosher and file number 25-01695. Appearance, please.
Hannah Buckingham on behalf of the people.
Good morning, man. Please come on court. Court. Kareem Johnson, on behalf of Mr. Motion, standing by me right.
Okay, we are ready to bring the jury up. My understanding is that there are no preliminary matters before the jury is brought up. Is that still active?
That's correct, Your Honor.
Maybe you could bring the jury up.
Addie, do you have my flash drive?
Yeah, that's right here.
Perfect.
You need the
Oh,
jury
I'm
box.
supposed to do that, oh, yeah.
I'm sorry?
I'm gonna leave. I just had a question for you. before I took off.
For me? seated.
Israel, you're juror number 2. Your name was called second. Who's juror number 1? You guys need to switch, please.
Juror number 1, Kaufman. Number 2, Howard. Number 3, Buxton. Number 4, Ryder. Number 5, Cook. Number 6, Trimble. Number 7, Morton. Okay. Okay, ladies and gentlemen, thank you for joining us this afternoon, or is it still morning? This morning. I am Judge Kristen D. Simmons, and it's my pleasure and privilege to welcome you to the 54A District Court here in Ingham County, Lansing, Michigan. I know jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution has the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified as a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your personal life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on a jury in one of 2 ways. First, I will excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand to answer or to swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have a religious belief against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. All jurors, both in the jury box and in the gallery, please rise. Just jurors. Thank you. and raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do so, signify by saying I do.
I do.
Thank you. You can be seated. I'm going to introduce my staff. To my right here is my court recorder and judicial assistant, Miss Addie Nash. Over here, the gentleman that helped escort you up in the blue suit, that's our court officer, David Warnsley. This is a criminal case involving the charges of assault and battery, which I will explain more fully later. This charge has been made against the defendant, who is named Aiden Mosher. The defendant's attorney is Mr. Kareem Johnson. Mr. Johnson, if you want to introduce yourself and please list any witnesses you anticipate calling today at trial.
Ladies and gentlemen, good morning. My name is Kareem Johnson. I represent this young man here, Aiden Mosher. The only witness defense will call will be Aiden Mosher if he exercises his right to testify. Thank you, Your Honor.
Thank you. Okay, and the assistant prosecuting attorney that will be heading this trial is Ms. Anna Buckingham. Ms. Buckingham is also assisted by Assistant Prosecuting Attorney Steve Wozniak. Please stand, introduce yourself, and list any witnesses you anticipate calling at trial.
Hello, everyone. My name is Anna Buckingham. As the judge just said, I'll be the prosecutor on this case with Mr. Wozniak, who's right next to me. And the witnesses that we intend to call will be Michaela Hatley, it's Hatley, Officer Tyler Ebright with the Lansing Police Department, and that's Ebright, and Gianni Rosario, Rosario.
Good morning, everyone.
Does anyone in the jury box or anyone hoping and praying to get in the jury box either recognize any of the lawyers or any of the witnesses that were named? Okay, very good. This trial should be done today. If anyone believes that the length of the trial will be a real hardship for you, please raise your hand. You believe it's going to be a hardship?
I do, depending on how long it goes. If it goes
Today?
Yes,
Why?
because I am a leader of the Girl Scout troop that starts 4 o'clock to 5:30 at Forestville Elementary, and I also have cookies that were delivered yesterday. I have to get to the parents who have orders to put out.
I apologize. Unfortunately, under the law, that doesn't qualify as a real hardship.
I do have a child, he's 12, he's 6th grade, he's at home. I just sent in an IEP to see, like, just to give him, like, whoever know what he's like at school. So that's just my hardship that I have.
I mean, your child's home now, or he's at school?
He's homeschooled, so he's online schooling at home.
Oh, okay.
And he needs a parapro, that's why he's not in school, because I couldn't get him one. So those are the two things. I do have proof of the.
I'm not discounting that you have
proof, sorry, I
a
did
child
send
in
that
school.
in.
If we excuse everyone who had children in school or even homeschooled, we'd never have a jury. So again, that doesn't qualify as a real hardship. Real hardship would be like, I have a doctor's appointment and I can't miss it because I'm scheduled to have surgery today. Like something like that would be a real hardship that I can release
It's
you
okay, I
from.
said a lot of parents, but not a lot of parents.
Yeah, no,
So I just
that's
wanted to
common.
put that out
Childcare is a common issue for jury. So and unfortunately, the Girl Scouts issue doesn't rise to the level of a real hardship either. Sir?
I was gonna say I have work today at 4, but
I think the majority of the people here today have work today. So unfortunately, that's not a real hardship either. So it doesn't sound like we have a hardship that I can qualify to release you for cause on. So nonetheless, some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes it difficult for you to sit for 2 to 3 hours at a time? We don't sit for 2 or 3 hours at a time. That's just the jury instruction. I try to give it a break at the top of every hour if it's a good time to break. But you definitely won't be sitting for 2 and 3 hours straight. But does anyone have a medical condition that makes it difficult for them to sit? Just raise your hand if you do. Okay. Anyone have a sight problem? And everybody see, it's a small courtroom. Can you see clearly? Everyone can hear me? Very good. If you can hear me, raise your hand. That's how I find out who can't hear. Okay, very good. Okay, this is a criminal case. The paper used to charge the defendant with the crime is called a complaint. The complaint in this case charges Mr. Aiden Mosher as follows. That on or about March 20th, 2025, at the area of 2514 West Jolly Road, Lansing, Michigan, the defendant in count 1 allegedly committed the act of assault or assault and battery, and that he did make an assault or assault and battery upon the following person: Gianni Rosario, contrary to MCL 750.81, and in count 2, assault or assault and battery, again on or about March 28th, 2025, at the area of 2514 West Jolly Road, Lansing, Michigan. The defendant did allegedly make an assault or assault and battery upon the following person: Michaela Hatley, again contrary to NCL 750.811. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal trial so that the defendant and the jury can hear the charges. You must not think that it is evidence that he is guilty or that he must be guilty because he has been charged. A person accused of a crime is presumed to be innocent. That means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. We will now begin our voir dire.
Yeah. So from now on, you don't have names. You are now a number. So we have jurors 1, 2, 3, 4, 5, 6, 7. Am I going backwards? Yeah. 1, 2, 3, 4, 5, 6, 7. And so this is the fun part because this is the only time I can talk directly to you for the day. So again, thank you for taking the time to be here. I know you don't have a choice, but it is really important. Our biggest goal here is to get the most fair trial we can for Mr. Mosher and also for the state. I'm going to start by asking you some questions. So have any of you, by a show of hands, ever been on a jury before? Yes? Anyone else? You have? Okay, so we have 3. Okay, I'm going to start with you. Without telling me exactly what it was about, was it criminal or civil? Criminal. And don't tell me what your verdict was, but were you able to come to a verdict with the jury?
No, I kind of asked you.
Oh, okay, so you weren't actually on the deliberating panel for it. Okay. How was that experience before that moment, Coria?
It was all right.
Was all right? Not riveting, exciting for you? No, bummer. And then I believe you raised your hand. Was it criminal or civil? Criminal. Okay. Do you remember about how long ago it was? Okay, over 30 years. Yeah, I don't blame you for having to think about what it was. Yeah. Do you remember if you were able to come to a verdict?
I was excused.
Okay. Gotcha. Okay. Did you all have fun in the jury selection process? Yeah. And then did you raise your hand as well? Okay. Was it criminal or civil? Criminal. And then were you part of the deliberating jury?
Yes.
Okay. And were you all able to come up with a verdict?
Yeah.
Okay. And how was that experience for you? It was okay. Just kind of had to be there. Okay. All right. So show of hands again. How many of you have parented a teenager? 1. How many of you have parented someone close to a teenager, like middle school? 1. Okay. Juror 6, can you go ahead and tell me a little bit about if you've ever had issues with your child being at certain locations you did not want them to be?
My oldest is a little bit of a different case because he is on the spectrum, so he would run. So not so much the school's fault or like whoever's, it's more his putting himself in dangerous positions and we have to chase him down.
Gotcha.
So probably, no, I'm gonna go with that.
Okay,
There's a
no,
little bit
not in like the
more-
classical sense of.
Yeah, like way you're answering your question. No.
Okay, gotcha. And then juror 4, can you go ahead and tell me a little bit, if you can recall a time, have you ever had issues with your team being somewhere you didn't want them to be? Do you have any fun stories?
Good question. Yes, but I usually heard about them after the fact.
Okay. Much later on?
Not all,
Okay, kind of figured it out.
somewhere in process, yeah. She was a teenager.
Okay, and juror 4, to kind of keep going with that, can you tell me some of the ways that you would assess if your team was lying to you?
The key one.
Sorry, can you repeat that?
Eye contact.
Eye contact.
Her eye contact would change when she was lying. She was more evasive. Trying not to have a conversation.
Evasive entirely.
Yeah.
Okay. Juror 1, can you try, like, juror 4 just talked about eye contact and just demeanor in general. Can you tell me some ways that you personally assess if someone's lying to you?
Not very much, other than, yeah, maybe avoiding eye contact, or like, if you ask a question that they then can't come up with an answer for.
Okay. Awesome. Juror 2, can you think of any other kind of metrics that you use if someone's telling the truth or not?
Say the same thing.
Same thing, like eye contact. How about juror 3?
Eye contacts for sure. I would say there's hesitation or stammering in their voices.
Okay, so that makes sense. Juror 6, or sorry, 5.
It's kind of a hard one to determine unless you really know the person, usually. That's my personal experience, I guess.
Can you think of any external factors you use if it's someone you don't know, kind of to gauge that honesty?
Maybe like the tone of their voice and just kind of how they represent themselves when they speak about it.
Okay, that makes sense. Juror 7, I'm going to skip to you. Can you think of any other metrics you use?
I would say.
Okay. Kind of like covering something up, just uncomfortable. That's a good one. I'm gonna kind of get specific here. In a situation where a minor may be at a party where alcohol is present. So if you can kind of think of that situation. Would you have any issue with blaming that minor being present if trouble were to arise because they were not supposed to be there? Juror 1, can you give me your thoughts on that situation?
So like, are they putting themselves in danger by being in that?
So let's say that there's someone who's at a party where alcohol is present, trouble arises. How would you feel about putting blame on that minor for the situation because they're in a place they're not supposed to be?
I don't
No? Can you elaborate on that at all?
It's just, I mean, that's not their fault if something goes wrong. Especially when you're younger. You do things sometimes that aren't smart, and you don't know it at the time.
Juror 2, can you give me your thoughts on that scenario?
Can you say the question?
Yeah, so think of a scenario where there's a party and maybe a minor is present, there's alcohol at that party, drinking going on, the situation arises. Would you in any way find yourself, what do you think about the blame being put on that minor for being present somewhere they're not supposed to be?
Well, I would object to that question. I think we're getting too into the facts of the case here in voir dire.
Repeat your question. I don't know the facts of the case, so I can't make an assessment because I don't know the facts of the case. Repeat your question.
I'm asking for general sense of blame being put on a minor in a situation at a party with alcohol because a situation arises.
Council approach.
I believe I left off juror 2, right?
Yeah.
Yeah. How would you feel about assessing, how would you go about assessing the amount of blame you would put on a minor being in a situation where they may not have been rightfully in that situation?
Depends if they were already told not to go, and they sort of go on.
Okay.
Because you know, most people, most parties always end up something bad happens.
So juror 3, thoughts on that scenario?
Yeah, I don't know how to answer that. I would. I'm assuming the situation is they're indirect.
Just from being present, kind of.
From being present, so I guess indirectly from them just being there, I would not.
What are some details you'd have to know to better assess that situation? That's fair. It's a pretty general question. So, does anyone else have, of the remaining jurors, have any specific thoughts about that kind of scenario that you'd like to chip in? No?
What they did there,
Mhm.
not how they ended, not how they got there first, but the choices they made once they were there.
That makes sense. So I'm gonna go back to talking a little bit about, we discussed, juror 4, we talked about you having teenagers assessing truth. Does anyone here have any thoughts about whether teenagers may inherently be more or less honest than an adult? Juror 6, I'm gonna start with you.
It depends on, like, I feel like the situation and the adult's involvement. If it's to keep them out of trouble, they're a good chance they're gonna lie.
Okay.
But I can't say that the alternative is gonna happen too, because there is a innocence with teenagers and kids that they don't always understand. And you're gonna get introduced into the situation and you're like, sorry, what was your question? I just.
And whether, just your thoughts on whether or not teenagers are inherently less honest than adults.
So, yeah, I mean, they don't want to get in trouble, so they might be less honest.
Okay, yeah. Kind of depends on the situation, obviously,
And it
but.
depends on potentially the outcome when you go home to that, like, what are they gonna deal with? So.
Juror 7, do you have any thoughts about that?
I would say, yeah, teenager. Less honest, you know, being like your said, they would most likely to get into so much trouble situation.
Okay. Can you think of ways that a teenager in that kind of situation, how you would gauge an honesty level of a teenager?
For me, because I have 2 siblings right now that are teenagers. I would come to them and ask them if they feel so they got into a fight. I would give them the time to tell me the truth, and if they don't tell me the truth, I'll tell them the truth.
Kind of gauge their reaction to that confrontation. Okay. Juror 5, thoughts about teenagers being more or less honest than adults?
Feel they may lie to get out of trouble more than an adult would, just because they don't really respect honesty quite as much as an adult would.
Okay, can you elaborate on that?
I don't know. I think that when you're youthful, you just kind of feel like you can get away with stuff more than when you're an adult. You might not see the severity of the consequences lying as you would as an adult.
With that thought in mind, in this case, obviously, you're going to be hearing from people of all different ages. With what are some of the contextual, what are some of the emotions that you look for? And I'm sticking with you, Juror 5. what are some of the emotions that you look for in this kind of setting to see if someone's telling you the truth or not?
Really having predetermined,
Probably depends on just the facts and.
just what I observed. I don't know if it's the person. We know what the clue specifically would be, but anything that sticks out. And that's goes for anyone really not age basis.
Right. So you all are going to be hearing from law enforcement in this case. Do any of you, by show of hands, have any of you had a negative interaction with law enforcement that you feel could impact how you listen to testimony from an officer? We're just asking for honesty so that we can make sure there's no issues. That has anyone had any negative interactions with police, let's say in the past year? How about the prosecutor's office? Has anyone had any negative interactions with the Ingham County Prosecutor's Office in the past year? No? Right. Let's talk about the hardest concept here, reasonable doubt. And I always say that because it's a nightmare even for people in law. It's kind of a conceptual hard thing to grab onto. I'm going to kind of victimize you guys a second and make us go down the line. And I'm going to ask you for your general, how you would define reasonable doubt. So starting with you, sorry, I'm going to bully you again. Starting with juror 1, how would you define reasonable doubt?
Just if there's enough evidence that everything kind of fits together, that everything makes sense to show that this really happened.
Okay.
Yeah, and if you do have doubt, you need something. Like, I think this thing isn't there, it's evidence isn't there, would make me think it's some actually.
Okay, makes sense. Juror 2, what do you think about reasonable doubt?
I would just say the same thing as not really good at explaining.
Okay. Juror 3, thoughts on reasonable doubt?
It's a tough one. I don't know how to explain it, except that logically, after hearing sides, then I would make a determination. I don't know how to.
So it's like, sounds like you're saying if you have a doubt, you're logically holding on to it and you're saying, does that make sense?
Yes.
Given, okay.
Yeah.
And are you comparing that to things in your own life and your experiences, or when you say, does that logically make sense to me? Can you elaborate on kind of what you use to evaluate that?
Even in a work situation, if somebody tells you something or tells you they did something or they didn't do something, it just doesn't sound right. And you know they did or didn't do something.
Sounds like a great explanation. So.
Okay.
All right, juror 4, what is reasonable doubt to you?
There aren't enough facts for me to form. Or enough.
Okay. Juror 5, what are your thoughts on reasonable doubt?
Tough one to put into words, I guess, but if you have a doubt, then what they're saying is essentially
Juror 6.
Kind of like it's different for everybody, obviously. Some people are gonna feel like there's something off. Some people are just gonna like logically be able to say that there's something off. But just that question, something is not meeting up with the evidence and there's just missing something. And when you have a question in the end and you're potentially going to like sentence somebody that should not be there, that question should not be there. I feel like that's reasonable doubt if you don't just have enough evidence, not even evidence, it's just something's missing and it's just not getting clarified. And maybe it's not evidence we have, or maybe it's part of a story that's not being told because it hasn't been done.
And I'm glad you brought that up, kind of missing puzzle piece, because that's something you kind of have to balance in this.
Yes.
Everyone understands that the prosecution isn't always able to give you 100% of the puzzle. Does anyone have an issue understanding that we might not have 100% for every question in finding a guilty verdict? Is that something that everyone feels comfortable that, yes, we might not get an answer to every single question that we have? But do all of you still feel in that scenario, if you had enough evidence and enough of the picture, that you would still be able to convict someone of being guilty? Yeah, does anyone have an issue with that? Not getting all the answers to every single question in the case? It's fair if you do, because obviously it depends, which is a lot of the answer. It depends on what that piece is. But if you're convinced of reasonable doubt, is everyone beyond a reasonable doubt, would everyone feel comfortable with giving a guilty verdict in that scenario? I'm gonna give and I'm almost done, I promise, with you guys. I'm gonna give you a fun hypothetical that the judges heard me give before. It's called the evil twin theory. It's a fun little hypothetical for reasonable doubt, and I want to get all your thoughts on it. So let's say that you are sitting in on a murder trial, and in this case, there is just overwhelming evidence. You have fingerprints on the body. You have a video that caught a license plate of the defendant going to the scene of the crime. You have his cell phone bouncing off the towers. And actually, there's a video, a little Nest home camera that captures the incident. And as the defendant's walking out, looks directly at the camera, and you say, that's clearly him. At the end, the defense attorney stands up and says, members of the jury, my defendant has an evil twin. And then sits down, and that's kind of the only rebuttal that happens in that trial. Juror 1, is that evil twin mentioned, is that enough to give you pause for reasonable doubt?
No, not unless you had like the alibi for the non-evil twin. Which I mean, as soon as they're putting out the evil twin hypothesis, then they need evidence that not evil twin was elsewhere. And like, did the evil twin steal their car, steal their phone?
And with all the evidence that I mentioned, is that what brought you beyond the reasonable doubt that now you feel like you need something to counteract that evidence? And that, so it's kind of like that proposition itself wasn't enough?
Yeah, it doesn't really make sense if the evidence is it's evil twin if you already license that belong to.
Okay. Juror 2, do you feel like would you be shaken by the evil twin proposition in that situation?
I'll have to see some evidence versus they actually have a evil twin.
And if it turns out that he does have an evil twin, how does that change your analysis of all the evidence that you've seen?
Personally, I actually have to show it also.
Can you speak up a little bit, sir?
You have to show me evidence that he was somewhere else to like show that he was innocent.
Does the fact that there's an evil twin negate the evidence that you've gotten so far?
Okay.
Does the fact that now you have a concept of an evil twin existing, does that negate all the other evidence that you've gotten so far? No? Okay. But you just feel like now you would have to have more information about this evil twin?
Yeah.
Okay. Juror 3, what do you think about that scenario?
Well, first, it would seem to me that the evil twin would come up sooner than the whole process, right? But assuming that didn't happen, yeah, it would give me some doubt as to whether the person sitting there is the guilty party or if he is.
And I want you to, and I'm sorry, I keep digging in
Yeah,
on you
no,
because you have good thoughts.
okay.
Is that doubt that you just mentioned that maybe it's the evil twin, given the entire situation and what you've seen up to that point, do you feel in that moment that that proposition of another twin, an evil twin, is that reasonable just given that information?
Just that statement alone,
Yes.
is that what you're asking? Probably not.
Okay. Move on to you. What do you think about the evil twin?
Well, just because somebody says it doesn't make it so. And again, I would want evidence. And I think you said there were fingerprints of the defendant on the body and the twin wouldn't have the same fingerprint, so.
Good catch. Sometimes people catch that one and throw that in there. Fair, that's true. All right.
Say something very similar to what we said. Just saying it would be enough to really.
Why isn't it enough?
And why did it just come up now, all of a sudden, randomly? And it seems like scapegoat trying to get out of something. Why would the twins come up way for background information? Throughout there.
Do you have more of a problem with it just randomly coming up, or do you feel like it in any way negates all the information you've been given?
Doesn't negate anything, it raises questions as to why it wasn't brought up sooner, or why people about this random twin.
You just want elaboration.
Right.
Yeah. Jurisdicts.
I feel like it's more to play on your words. I don't think would give you too much of a doubt on the evidence, because like you can be fraternal twins with somebody and still have very much different DNA, fingerprints, whatever. If you're identical, that would be a little bit more, I guess, harder to persuade, I guess. It might give me a little bit more, depending on like the technicality of your words. I also kind of feel like if it's just being thrown out there, like as a defense, I don't even know. Maybe just another way to put the blame somewhere else and to take that extra time to do, I don't know. It just kind of throws it a different direction to leave the blame somewhere else potentially.
So you would, in that situation, you would not find that reasonable?
Not really.
Not really.
Oh,
Is
sorry,
there any?
I do that a lot.
Oh, that's okay. I'm just thinking, I do that too, but.
Yeah, no, yes, a lot of times. I
No.
put those extra words at the end.
Got
So,
it. Jury 7.
If, like, say if it's like halfway through the case, and then the defendant's lawyer just puts up, yes, and he was winning, I would have to sit there and ask how come he didn't bring this up sooner.
Well, let's assume that the way this normally works is the prosecution goes first, and then if defense wants to put on a defense, which they don't have to, and you get instructions about that. Let's say that it's the normal procedure of the case, but that's just the only evidence that this defense attorney decides to bring. So I'm more asking, does that thought that there might be an evil twin that's been brought to your attention, does that in any way negate? Well, so let's say you're beyond a reasonable doubt. You're saying I have all this evidence. I have all this evidence I want. Does that proposition that there might be an evil twin, how does that make you feel about all the other evidence?
I don't think
Okay.
I'm struggling to hear his answer.
Sorry. I don't think it would be doubtful for me to think this evil twin that suddenly now exists, but all the evidence is all pointed to the actual twin. Fingerprints, things like the camera, are the text messages, our calls, all logged and exposed into this one person.
Let's say we now find out the evil twin exists. How do you feel now in that situation?
I would have to see proof.
Let's say you get proof that it does exist.
Then I would ask, how does this was kind of proof. I would ask to like get an outline for the twin that's on trial.
Let's be clear, you all are jurors when this question is being brought to you. You're asking for all this information as a juror.
Yes.
Okay. I'm just gonna do kind of a catch-all question for you all now. Does anyone have anything that I haven't asked you that you feel like could really impact your ability to find someone either guilty or not guilty in this trial? Does anyone have any experiences that you think might bias you in this case that you think, I just don't know if I can do this, I feel uncomfortable? Sure. One, do you have anything that I haven't asked that you're like, she probably should ask that? No. No. Okay. Juror 2. No. Okay. Juror 3. No. 4.
I do have a master's in communication. project.
Great to know, because now I want to ask you a harder question. We talked about ways that you can gauge if someone's lying or not. Can you think of a reason that someone might come across as dodgy or nervous despite telling the truth?
I suppose they could, if they're really nervous.
Yeah. Does anyone know what the biggest fear in America is? In the US?
Publicly speaking.
Yeah, statistically, it's going to be public speaking. Yeah. That might be a reason, right? Someone just getting up in front of people. You guys probably feel a little uncomfortable even just in your chairs. So it's kind of reasonable that under talking about a situation that clearly was a contentious situation, that might cause some nervousness. So yeah, any other reasons you could think of that people might be?
Is this alcohol related?
No, this is just in general. Can anyone else think of any reasons someone might be coming across as no eye contact, nervousness, that might not necessarily be because they're telling a lie? Any other reasons?
Anxiety.
Anxiety, yeah. Awesome. Yeah.
Could just be like a really high stakes situation where they, like what I say really matters, so I'm really nervous about it.
Yeah, totally.
They could have some mental situation that would cause them.
Maybe some social, yeah. Okay. I don't think I got down to you guys. Anything that you want me to know that I might not have asked you about?
Sure. Actually,
Oh, okay. How about the question before that? Does anyone have anything that I didn't ask that you feel like I should know about you serving as a juror? No? Okay. Well, thank you for your time.
I just want to follow up on this, because I did struggle to hear part of your response, but I think the evil twin question, just to make it clear for me, the mindset, some of you all said that you would want to see other information. And so the way the process works is the prosecution is going to present their case. The defense can present a defense, or they don't have to do anything. By law, he does not have to say anything in his trial. If that scenario that the prosecutor gave you, that there was an evil twin, created some questions about other information that you say you wanted to see, but they didn't present it. Because you don't get to be as a juror to come back and tell the prosecutor, will give me this. They present their case, and that's what you have to decide with. If you don't have those things, and that goes back to a previous question she asked about if I can't answer all the questions, does that create a doubt? And then you ask yourself, if you have a doubt, is the doubt reasonable? That's your job. If you have a doubt and it's reasonable, you cannot convict the person. You have to convict beyond a reasonable doubt. So if you have a doubt, but the doubt doesn't make any sense, like she said, well, there's fingerprints, and even identical twins don't have the same fingerprint. Well, now the doubt's not reasonable. And so then do you have enough to convict beyond a reasonable doubt? So that's why this reasonable doubt concept can be very difficult for people to understand, because they think that it has to be beyond any doubt, or that they can't have any doubt. You can have a doubt, but then you have to now determine, is this a doubt that's reasonable? And when you go to deliberate, you'll be able to discuss this with your other jurors, because you might think the doubt is reasonable till you hear or talk through with them. And then maybe you all didn't know that identical twins don't have the same fingerprint, but juror number 4 knew that. And so that helps to answer some of the questions. So hopefully that clarifies a little bit more about the scenario. What dear?
Ladies and gentlemen, good afternoon. Good afternoon. Good afternoon. Again, my name is Kareem Johnson. I represent Mr. Mosier, sits right here. I know some of you may not want to be here, but I love being here. As a criminal defense attorney, I love being tasked with the responsibility of being that last line of defense between the citizen and the government. The individuals who founded this country decided that when the government accuses somebody of a crime, that person should be entitled, number one, to have a criminal defense attorney represent them. And it's important because those people who founded that country knew that when you went to court, everybody there worked for the government. So it needs to be somebody there that doesn't work for the government. And it was so important to them that the criminal defense attorney is the only non-elected, non-politically appointed occupation in the US Constitution. Anywhere the flag of America flies, somebody is convicted or accused of a crime by the government, they are entitled to a defense attorney. So that's why I'm here, okay? Now, the second most important thing that you guys need to understand, because there's been some comments to the contrary. You are here to decide if the government can prove a case beyond a reasonable doubt that they decided to bring against one of their citizens, Mr. Mosher, excuse me. Now, Judge Simmons told the 7 of you right now to render a verdict. What would that verdict be? Say it louder, man.
Not guilty.
Why?
Because we haven't heard anything that's the contrary.
Exactly. Does everybody agree with that?
Yes.
My client is presumed to be innocent. He was innocent when he walked in here. He is presumed to be innocent as he sits there, and he's presumed to be innocent until and if the government can prove otherwise beyond a reasonable doubt. Do you all understand that now?
Yeah.
So if Judge Simmons instructed you right now to render a verdict, what would that verdict be? Y'all saying it like it's a bad word. As a defense attorney, it's one of my favorite 2 words. If Judge Simmons instructed you right now to render a verdict against Mr. Mosher, what would that verdict be?
Not guilty.
Okay. Now, and Judge Simmons, being the judge and understand what needs to happen, has clarified this. I'm gonna spend a little time on it. We don't have to do anything. My client and I can sit here and play poker during this trial. We don't have to bring up before time or before this trial any reasons why he's not guilty. The police should have did their job. Does everybody understand that?
Yes.
Now, the one thing I don't like about the jury instructions that the court gives is they're too apologetic, they're too nice, right? What we're looking for here is honesty. I get a reasonable time, and that's determined by Judge Simmons, to basically do legal speed dating to try and figure out who the best 7 people are to make a decision about my client's life, right? So all we ask of you is what I call living room honesty, okay? You can't get in trouble for anything you say here. And when I say living room honesty, like my family, if you catch them out in public, they'll give you views and opinions. And sometimes I'll be looking like that ain't what you really think, right? But when we at home behind closed doors and nobody's recording at Thanksgiving dinner, Christmas dinner, they have all kind of different opinions that they wouldn't admit in public. Am I the only person, or anybody else got family like that? Okay, good. So when I say living room honest, what you pretend like you're in your living room talking to those who are the most trusted by you. Does everybody agree to do that? Now, who believes the court has given an instruction on the presumption of innocence? And you've agreed and taken an oath to follow that instruction. But I want to know who really believes that. Who really believes that if the government accuses you of a crime, you should be presumed innocent? Everybody? Good. Now, my client also has the right to remain silent. He does not have to participate in the prosecution against him. Let's do is show up, say not guilty. The court has given you an instruction on that. But I want to know again, how many of you believe that? Believe that if somebody accuses you of doing something, if the government accuses you of doing something, you should be able to sit there and prove it, right? Because I know that doesn't happen in real life, right? I know if I get accused of something, or my wife says, well, I told you to do this and you didn't do this, or did you do that? I can't say to her, I've exercised my Fifth Amendment right to remain silent. You go have at it, prove it, right? How many of you believe that? Believe that an individual should have the right to remain silent when the government accuses them of a crime? Okay, good. Now, we talked about reasonable doubt. And it's been talked about twice. Now, I'm not going to ask you what you believe reasonable doubt is, because quite frankly, it don't matter, okay? The court is going to give you a definition of reasonable doubt. And the definition the court is going to give you that you've taken an oath to apply is that a reasonable doubt, proof beyond a reasonable doubt, is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginable doubt or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful consideration of the an examination of the facts and circumstances of the case. Does everybody understand that? Does everybody think they can apply that? Okay. So, at the end of this trial, I know me specifically, for those of you who are lucky enough to be here, we will be talking about evidence presented and not presented as reasons why my client, should be found not guilty, should continue and keep that presumption of innocence, all right? Does everybody think that's fair, that you should consider evidence presented and evidence not presented? Everybody? Okay. Ma'am, you.
I'm just curious why it wouldn't be presented. How would I know about it if it's not presented?
Maybe it doesn't exist. And we'll talk about why it doesn't exist, right? So, okay, get an example. Government accuses Kareem Johnson of bank robbery, right? They arrest him. They bring him in, send him on trial. Kareem Johnson robbed the Comerica Bank in downtown Lansing. My lawyer gets up and asks every witness, did you ever find any money? Did you ever find a gun? Did you ever find a mask? And he gets up in his closing argument and reads that instruction and says that absence of evidence, never finding any money, never finding a gun, never finding a mask, should give you reason to doubt the prosecution's case against Kareem Johnson. That seem fair? Everybody understand that? Okay.
Well, I don't know what the evidence was.
Well,
I still don't know what the evidence was.
Again.
You told me what it wasn't, but
Right.
not what it was.
So the
In your
question.
example, so I can't answer the question.
So you can't answer the question. Okay, and that's fair. And thank you. Now, we talked about teenagers and telling the truth and things like that. I have little cousins, and sometimes they get to telling me a story and I'll just go, I'm gonna stop you right there. Before you say one more word, I want to remind you that I've been your age and you ain't never been mine. Okay? And then sometimes they just decide not to say anything else to me. And I remind them that I'm kind of closer to your age than your parents. So what you may be able to get on them, you ain't gonna get over on me. Okay? Anybody ever had conversations like that with siblings or younger family members? I see a couple of hands going up. Now, the court, again, people much smarter than me have wrote an instruction on witness credibility. And one of the things you're gonna hear in one of the instructions is, does the witness's age or maturity affect how you judge his or her testimony? And I surely will be asking to consider, the age and maturity of potential witnesses in judging their testimony. Do you agree that a witness's age and maturity is important in judging their testimony? Raise your hands if you agree. Somewhat?
Yeah, somewhat.
Okay. And ma'am, you don't think that's important at all? Not if it's not relevant, okay. The thing I hate the most about the American judicial system is we know people come in here, sit in that chair, swear to tell the truth, the whole truth, nothing but the truth, and lie. The jury instruction is going to tell you on witness credibility to consider if somebody had a special reason or motive to lie, right? It even tells you what to do if you think somebody has deliberately lied in this case and what you can do with their testimony, right? And, well, I don't like it. I guess I understand it. I mean, one of my favorite presidents sat in a chair just like this and under oath said, I did not have sexual relations with that woman, right? Most people thought he was lying. Most people thought he had a good reason to lie. Being asked about some side chick on TV in front of the whole world, and most importantly, his wife. I think most people said, yeah, you're probably lying. We understand why you lie, but we're going to take that into consideration when judging your credibility, because we don't believe that you're brave enough to admit things harmful to you when you're in trouble, right? And the jury instruction kind of gives you those three options. The jury instruction that you're going to hear on witness credibility at the end is going to say, however, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness has said. On the other hand, if you think the witness has lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. That is the instruction I hate the most in our criminal justice system. Because although I do this for a living, it is very hard to prove that somebody lied unless they admit, yeah, I lied when I previously said something. And after you go through all that to prove that somebody that you guys don't know has lied, then the jury instruction says, well, you can just ignore that part if you want to. So my question to you is, you've all have acknowledged that you don't know these witnesses. If you make the determination that a witness deliberately lied about something, do you think that is important in determining their credibility as to other issues? You find or believe that a witness lied about something in this case. Do you think that's important when it comes to determining their credibility on the other issues? Well, I think the prosecution gave an example about teenagers, right? I know my kids, right? I spend hours with them every single day. I can look at them because of the familiarity I have with them and say, no, you're lying about that, but you may be telling the truth about this, right? But with a stranger, I don't have that familiarity. So I know I am less likely to try and differentiate with a stranger what they're telling the truth about and what they're not. See some of you shaking your heads. You agree with me? Okay. One of the reasons we have this chair here, so you can make observations of the witness that is here. Okay. Everybody that sees this chair, does anybody think there's anything magical about this chair that make the witnesses that sit in it tell the truth? You have heard that this case is about assault and battery. Is anybody here that thinks, people should just keep their hands to themselves and there's never a good reason to put your hands on somebody else? So a lot of people raise their hand, right? Say, for example, some stranger runs into this room right now, all irate, and starts grabbing on me, and I turn and punch him. I've now put my hands on somebody. Am I wrong for that? Okay, so then you do think there are some circumstances in which it's okay to put hands on somebody? Come on, people, we are in America. This country was founded off of a fight, right? We took the tea, threw it in the river, and then fought the British soldiers. Yes, ma'am.
I wouldn't say it's okay to put someone's hands on somebody else, but in the circumstance where you are being attacked, it falls on that yourself defending yourself. So it. So like, no, it's not okay to put hands on somebody, but there is that gray area.
The complaining witnesses in this case are also female. I believe the prosecution is going to allege, based on what was read and while we're here, that my client, who is male, supposedly put his hands and assaulted these females. Likewise, you won't hear he or she a lot in the jury instructions. The jury instruction for assault and battery doesn't make any distinctions between male and female, right? Is there anybody here that thinks that there's never a reason under any circumstance for a man to put his hands on a woman? You kind of shaking your head. No, please be honest.
There's never a reason.
Okay, so my client has pled not guilty and that he has not done this. Will hearing testimony and accusations about a man putting his hands on a woman bother you to where you believe you can't be fair to my client?
I feel like I would be impartial.
Does everybody feel that way? And now, what do you mean by impartial?
Well, I would hear the evidence and make a determination, but given the instructions, he's not guilty until.
Thank you. Does everybody agree with that? A lot of judges don't like this question, but it is what it is. Who just don't want to be here? And if we are here to 5:30, 6:30, 7 o'clock deliberating, and you guys, whoever the deliberating jurors are, will deliberate until you either reach a verdict or decide that you can't. Who here is like, you know what, I didn't even want to be here. I'm done. I may quit on deliberations, or I just give up because I don't want to be here no more. Remember, you can't get in trouble. Okay, thank you. We have the ability to send you home. Okay, you know, okay. Now, I always say that.
Either one of them can remove you. They get 3 times to be removed from someone for no reason.
I always remind you, I hope you never have to meet somebody like me. And I hope you never have to sit where my clients sit. But if you were sitting here because the government accused you of doing something, you said you were not guilty, would you want people to care? Or would you want them to, I don't want to be here? Like, have you ever watched the news and saw a verdict that you didn't like and got upset about it, thought it was unfair, or thought it was BS? I want you to think about that before you say, Mr. Johnson, send me home. I don't want to do this civic duty of jury duty. Y'all want to go home? Thank you. What the Constitution and the framers of this country wanted. I'm getting paid to be here. I mean, I don't make no qualms about that, right? Y'all get paid, but not as much as we are. I mean, that's just, it just is what it is. But we cannot have this process without you. And the government only asks American citizens to do 3 things: pay taxes, men of the age of 18 have to register for selective service, and come to jury duty when summoned. So we do thank you for that. And we thank you for caring about somebody that you've never met before today, and you may not see again after today. Thank you. No further question.
Any challenges for cause?
None for cause.
None for cause, Your Honor.
Any preemptory?
None from the people were satisfied, Your Honor.
Your Honor, defense would like to thank the excused juror seated in seat number 4.
Juror number 4, you may be excused. Put someone in number 4. Replacing juror number 4 is going to be Cynthia Collins. You can question the new juror number 4.
Thank you. Hello, welcome to the hot seat. This is kind of usually the rotating seat, so hopefully we get to keep you around, but I'll just start by asking, did any of the questions that we already have gone over, did any of them kind of ping in your head or stick out to you that you wanted to talk about with me? Do you, I see in here, it looks like, well, what do you do for work? Currently unemployed? Were you a scientist? Okay, that's what I listed here. So I was gonna ask, what did you do in that role? I have a few friends that do Great Lakes research and they kind of went through that field and then ended up doing more biological samples and then do all the data. Did you end up kind of the field that you thought you'd end up in, or how did you end up in that specific area?
I started in plant science and
Okay. So just kind of clicked. Yeah, this is familiar. Awesome, very cool. Let's go to that question about judging someone's honesty. What are some of the things you look for when, let's come up with a scenario. You have two people that are both telling you completely opposite things. What do you use to gauge who's telling the truth?
it's hard. Like you can look at their mannerisms and if you know them, you might be able to judge their motive.
How do you feel generally about being here today? Yeah. Do you feel nervous at all?
A little hungry.
I don't blame you. I'm also hungry. Do you? Well, actually, let's go all the way back. Have you ever been on a jury before? Okay. How long ago was that? Okay. Was it criminal or civil? Okay. Did you guys come up with a verdict? Did the deliberation take just the right amount of time, or did you feel like it took way too long, or how did you feel about that? It took the right amount of time. Do you feel like you came to the right verdict, like personally?
Yeah.
Yeah. Are you someone that you feel like if you really firmly believe in someone's innocence, that you'll hold out for that person? Right. But also in that situation where you kind of bouncing off, conversing with everyone else, felt like that was equally as important to you in that situation. Well, how have you had any negative interactions with officers, anything like that? Give me an example of what popped up in your head.
I mean, I'm from a small town. Everybody knows everybody. A lot, and I'll know if they were driving past my house and watching my activity.
And I think I've had good interactions with officers too.
Do you feel like you're able to kind of set that aside and like if an officer's on the stand, what are your thoughts? Are you just kind of like, that's a totally different person? How about prosecutor? Do you have any feeling towards prosecutors? Anything like that? Anything in your own personal life you feel like I should know about? Thing that would make today difficult for you, sitting with a juror? Okay, thank you.
Good afternoon, ma'am. Good afternoon. Were you able to hear all my questions? Do you have any different answers, opinions? You believe in the presumption of innocence? Believe in the burden of proof? Believe in that right to remain silent? If you asked a question about trying to hear two completely different stories and trying to decide who's telling the truth, right? Remember that? When those people have the presumption of innocence, does that make it a little easier?
Innocent until proven guilty.
If we had to render a verdict right now, what would that verdict be?
After watching everybody else, at first I would have said, I don't know, I haven't heard anything.
Well, I don't want you to
Then
base
you
your-
brought up, oh, I haven't heard anything, so prove anything, so innocent.
No. You have the right to say, Ms. Johnson, I don't care about that. And I don't care about what these other 6 people, 7 people say. Okay? Do you believe that? Sure, it's okay if you don't. And I guess lastly, no further questions, y'all.
Challenges for cause.
None for cause.
None for cause, y'all.
Preemptory.
None.
You know, defense like thank you, juror seated in seat number 6.
Jury number 6. Counselor, if you could vote for vote. You can save it.
All right, okay. Thank you.